This is the second bench warrant in this matter, with bond currently set at $1,188. The failure to appear was on January 4th, 2023 for an adjourned show cause before your honor. Currently, she reports she is working at both Kohl's and Heartbeats. The last payment made on this docket was April 25th of 2023. That was made on her own. Friend of the court requests the next hearing be set for October 11th at 8 a.m. before your honor.
Okay. Ms. Hall, you're before the court charged with a civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenant at the next hearing on October 11, 2023 at 8 o'clock a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
Of 1,000? No, I'm not. I currently don't even have a living situation. No.
Okay. And how much? How much would you be able to post? Do you know?
Can we? Because I have a bond set at 500 for my other one. I can do that. And then can we do 300, 400?
Well, the court does note that it's your second bench warrant, so the court is taking that into consideration. The court will set your bond in the amount of $400. If you're able to post that, you'd be able to be released. Do you have any questions?
Okay. No. Also, I'm not employed at Kohl's any longer.
Okay. We will make a note of that. Anything else, ma'am?
No, that'll be it.
In this matter, Ms. Ashfield to appear for an adjourned enforcement hearing before your honor on April 9th of 2023. Part of that order was a commitment that was signed back on February 15th of 2023. It indicated she was to serve 10 days with 5 days credit and a purge of $788. That was adjourned out to the April 9th date when she failed to appear. And this is the second bench warrant.
I would actually like to do 30 days with time served if I could, please.
Okay.
I would like to try to start fresh.
Okay.
Sorry.
Well, what the court's going to do in this matter, the court does note that the court had previously ordered you to serve the 10 days. Yeah. And as a result, the court is going to, again, the court's going to enforce that particular order that you do serve the 10 days in this matter. So the court will not set a bond at this time, and you can serve the time that you'd previously been sentenced to.
Okay. So not 30 days, just 10 days.
What it was 10 days, wasn't it, Ms. Plattick?
It was 10 days with 5 previously served.
Yep.
Oh, okay. I thought it was 30. Sorry.
No, we could give you 30 if you want, but
that's fine. Okay. I'm being honest. Okay. I want a clean start when I get out.
Okay. Okay. Well, then you just serve the balance of your time, 5 days, and then you'll be able to be released. Okay.
Thank you, Anna.
Thank you.
UN. In both of these matters, Mr. Curtis failed to appear on July 19th of 2023. That was an adjourned show cause before your honor. In both matters, this is the third bench warrant, and both bonds are currently set at $500. Mr. Curtis does report he is employed through Climax Solar at this time. Last payments voluntarily were June 21st through income withholding. He also did have a $100 bond forfeiture in each of these matters that applied in July. Friend of the court is requesting the next hearing be set for October 11th at 8:45 before your honor.
Okay. Mr. Curtis, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenant that the next hearing on October 11, 2023 at 8:45 a.m. you will get notice of that in writing. Are you able to post a bond, sir?
No, sir, not at the moment. I just applied for Climax Solar, and the manager also, he told me that I will be starting either today or Friday.
Okay.
And yes, sir, I've been off work since the last time I was here. I ended up losing my job the last time that I was here. And I posted bond then, and I gave up everything, and I've owed people who made that bond for me. So I've tried to pay back the people that I owe and trying to get back on a good foot, sir.
Okay. Well, what happens is we set your bond in the amount of $100 previously, and unfortunately, that wasn't sufficient to get you to court on the 19th. What I'm going to do is I am going to reduce your bond because you've only had 3 bench warrants in hopes that you could I'm going to set your bond in both cases in the amount of $200 each, and hopefully that will get you to court on the 11th. So if you're able to post that, you'd be able to be released. Do you have any questions, sir? Okay, thank you. You're free to go. Have a good day.
In this matter, Mr. Harrington failed to appear on June 13th of this year for a show cause before the referee. This is the first and only bench warrant with bond currently set at $4,756. He reports he currently receives disability through the VA. The last voluntary payment made to this case was in March of this year. However, there are payments. He is making payments every month, but they're going to a different county's case. Calhoun County's not seeing any of that money. Friend of the court requests the next hearing be set for October 11th at 8 a.m. before your honor.
Okay. Mr. Harrington, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 11, 2023 at 8 o'clock a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I should be able to, yes, sir.
Okay. How much would you be able to post?
I really don't have a whole bunch of money right now.
Okay.
I really don't know, sir.
Okay, let me do this. Court's going to reduce your bond substantially in hopes that you could be released. I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay. Thank you, sir. You're free to go. Good morning to both of you.
Thank you, sir.
This matter is before the court today for a scheduling conference, and the scheduling conference is where we set in place various dates as to what processes are going to take place so that the case will proceed in an orderly fashion. And I'll first turn to the plaintiff to find out what he believes to be the issues in dispute. Sir, what do you believe that you are, again, disputing, or what's going to be contested in this matter?
It would be getting full custody of my son. Because this all started because of a case with CPA.
I don't need to know that. I just need to know what the issues are, sir.
Okay.
At this point.
Okay. Thank you.
Are there any issues concerning property, spousal support, whatever?
No, just custody of my son.
Okay, just child-related issues. Ma'am, what issues do you believe to be in dispute?
Just child custody.
Okay. Okay, I don't know if you've done any discovery in this matter. Discovery is the process whereby you can acquire information from the other side, and you can do that through interrogatories, requests for production of documents, depositions, or any other forms of discovery provided under the court rule. Do you anticipate, sir, having any discovery in this matter?
I am planning to, yes.
Okay. And ma'am, do you anticipate any discovery?
Can you say again what the discovery is?
Discovery is whereby you acquire information from the other side, whatever information you need to discover.
Oh, yes.
Okay. What I'll do is I'll put December 1 as the discovery cutoff date. And again, so you'll have to get on that because it does take time to get discovery in place, okay?
Okay.
And then the court will set the matter for mediation in December. The mediation process was whereby an attorney mediator would get together with the two of you and attempt to resolve any disputes that might exist. Sir, do you have any mediator that you would recommend in this matter?
I don't right now, no. Okay.
Ma'am, do you have any mediator you would recommend?
Not at this time.
Okay. What the court will do then is the court will leave it up to the mediation clerk. She will randomly assign a mediator in this matter. I will tell you that there's a cost associated with that because they obviously don't work for free, but they will, once they're assigned, then I'll leave it up to you, sir, because you are the plaintiff. You're going to have to coordinate it with the mediator to schedule a mediation sometime in December.
Okay.
Okay. What the court will do then is the court will reset this matter for a settlement conference in January. I'll set it for January 8th. It'll be 1:30 p.m. Parties are required to be present unless we come to a full resolution due to your failure to pay child support and or related expenses. Upon a first conviction, you could be able to order to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
Yes.
The court would advise you have a right to an attorney. The court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
Yes.
Thank you. Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay, thank you.
The respondent, Nathan Soria, is before the court for a bench warrant hearing because he failed to appear for a show cause hearing on August 24th, 2023 before referee Delmont. This is an interstate case, and we're enforcing a Florida order that was registered in Michigan in June 2022. Mr. Soria is ordered to pay $307.88 per month for current support, $61.58 on arrears, for a total monthly obligation of $372.96. The last payment received on this docket was on September 11, 2023, in the amount of $500, which was a payment to have his bench warrant recalled. This is the second show cause, first bench warrant, and he's had one previous finding of contempt. And measured his compliance over the last 6 months, Mr. Soria should have paid $2,237.76. He's paid nothing, so that is a shortfall. Total arrears on this docket are $21,805.28 through September 30th. Friend of the court would like to note that Mr. Soria did have a hearing on June 29th, 2023. He was found in contempt at that time, ordered to serve 31 days or pay a purge of $1,000, and he did pay the purge. Those two purges, well, that purge and this bench warrant payment are the only payments that have been received on this docket since it's been registered with Michigan.
Okay, thank you. Mr. Sackrider, do you contest or dispute the testimony given by Ms. Mouton?
No, Your Honor.
Okay. Do you have any questions for Ms. Mouton?
Yes, I do.
And go ahead.
All right, Ms. Mouton, since the obligation was transferred to Michigan in 2022, has Mr. Soria been served with a copy of the support order?
To my knowledge, paperwork has been mailed to Mr. Soria. So, and we have received no return mail, so it would be in front of the court's assumption that he has received that paperwork.
All right. Have you ever had any contact with Mr. Soria?
Yes.
All right. Is he eligible for the LEAP program?
He is not. He lives outside of the service area.
All right. Thank you. All right, I have no further questions.
Okay. Any proofs, Mr. Sackrider?
Yes, I'd call Mr. Soria.
Okay, go ahead.
All right, Mr. Soria, you heard the testimony of Ms. Mouton. Was there anything that you disagreed with?
No. I mean, other than getting my mail, I have not been receiving mail. I don't know where it's going, but it is not coming to my drive address. And I believe I just talked to Ms. Mouton today for the first time. And I did get the information where to send payments. She gave me a P.O. box address. But other than that, I have nothing.
All right. She testified that you missed a show cause hearing on August 24th, 2023. Did you have notice of that hearing?
I did not. I got notice after. I believe it was a Thursday. Amber Roach had sent my daughter that lives in the state of Michigan a picture stating that I missed court. But other than that, I have not missed court, or I wouldn't have missed court if I had any information on my court date. I would have been there.
All right. When did you learn that the child support enforcement case was transferred to Michigan?
The very first court date that we had, I'm not even sure when it was, but it was through Calhoun County. Not the one I missed, but several months before that.
All right. Did you update your address with the court?
The court has the correct address. I've called in, talked to several different secretaries from the Friend of Court and several different departments, and they tell me that my address is in their system. My address has also been changed through the post office, so I don't understand why I'm not receiving my letters.
All right. When did you move to that address?
It would have been December 25th of 2021. It would have been Christmas Day of 2021.
All right. All right. She testified that your child support obligation is $307.88 per month. In addition, there's arrears and service processing fees totaling $372.96. Were you aware of that?
I was not aware of my arrears or what my actual payment monthly was until this morning when I asked how do I pay those.
All right. Are you currently working?
I am not. I've had an extremely hard time finding work here in Michigan. I've done odds and ends, but other than that, it's not very much.
All right. How are you supporting yourself?
Like I said, I find odds and ends as little jobs that I can. Other than that, I, do stuff around my house and what I can to get by.
All right. How much would you say that you earned in the past month?
Maybe $700, and I had to pay at the time I had to borrow money from my mom and pay my mom back for the $500 that I had to pay for the bench warrant due to missing the last court date.
Okay. Who do you live with?
My fiance.
All right.
And my 9-month-old daughter.
All right. What are your expenses?
I have a cell phone bill that I have to pay monthly. I have food expenses. My 9-month-old daughter, if she needs something. I have daily expenses. If I have to go somewhere, I have to give somebody gas money if I can't get there in a walking distance.
All right. Who owns the house that you live in?
My fiance.
All right. Have you been looking for work?
I have. I've had several job opportunities, interviews. I go in for my orientation and my interview. They'd hire me in. I had a job at Myers Distribution a while back. I did my interview, my drug test, all my paperwork. They hired me in. I went to start my first day, and they said my background check had came in, and I was terminated. I wasn't eligible to enter the building due to my background.
Okay. What in your background prevented them from hiring you?
I have 2 felonies, I believe it is, and just a list of misdemeanors.
All right. When was the last time you were employed?
The last time I was employed, I worked at Clemens in Coldwater. It's a slaughterhouse. And at that time, they were taking child support out of my check weekly.
When was that?
It was before Christmas of December 2021.
Okay. Let's say per week since that time, how many jobs would you say you applied to?
I'd say at least 100, if not more. I moved to Michigan, filling out job applications left and right. Did several interviews. I went around here to the staffing agencies, and due to my background, most of them couldn't find me anywhere that would accept me with my charges.
All right. What's your highest level of education achieved?
10th grade.
Okay. Have you ever attempted to get your GED?
I have. I've tried once while I was in a work release program in Indiana. And then I tried to do my online classes on my own, and I wasn't able to complete the test at that point.
All right. Is there any amount that you could pay today?
I have $122 to my name in my wallet.
I could go get a money order and send it in. I'm 3 hours away from Calhoun County. I can overnight it. That'll cost me a few bucks. So maybe $100 I could pay today.
All right. What's your plan for paying the obligation in the future?
I'm just gonna try to set a little bit back on each job and send it in as what I can. I mean, I can't guarantee that I could make enough to pay the full 4 something a month, but I mean, I can try.
All right. Anything else you'd like to tell the court?
No.
All right. Nothing further, Your Honor.
Okay, thank you. Mr. Saria, in this particular matter, you've stated you had difficulty finding work, but you probably have been around town and realized that there is a substantial need in the workforce, and that there is, in fact, most every business has a help wanted sign in their window. Why haven't you been able to find employment?
Most of them, well, all of them do a background check. I have some pretty nasty felonies from when I was younger on my record. And even some of them that do the second chance. I've been to a few places that do second chances, and they wouldn't hire me due to my record.
So you could say your past has caught up with you.
That it has, Your Honor. I didn't know. They always told us, but we never believed them when we were younger. If I knew it was going to affect me like this, I don't think I would have done all them things I did when I was a kid.
You said in the past month that you made approximately $700. Has that been consistent, let's say, over the year, give or take a little bit, that you make that much per month?
I don't normally, I guess it just fluctuates. I find jobs here and there on Facebook as I can, people asking for yard work, people asking for, carpet replaced or painting. I mean, I find jobs like that, and it's not ever easy, especially somebody trusting a stranger in their house nowadays.
Is there anything else that you'd like to tell me, sir?
No, Your Honor.
Anything else, Mr. Sackrider?
No.
In this particular matter, the respondent has testified. Let me say before that, Ms. Roush, is there anything you would like to say? Ma'am?
Are you speaking to me?
Yes. Is there anything you'd like to say?
No, Your Honor. No.
Thank you. Well, court heard the testimony in this matter. It's clear that Mr. Saria has had, again, knowledge of the action being registered in Michigan from Florida. He's acknowledged that during the last proceeding that he was aware that it came to Michigan, that, again, his last payment has basically been involuntary payment other than the purge amount that he paid as a result to avoid the jail sentence in this particular case. He stated that he's not working, that he's had a hard time finding work. He acknowledges it's based upon his record and that he acquired, obviously, when he was younger, but unfortunately that stays with you. He did state that in the last month he'd made approximately $700, but he didn't pay anything towards the obligation in this particular case, as he had other expenses. He did have stated he'd had difficulties acquiring employment. He had a chance to work at Myers Distribution, but once they did the background check, that he failed that. And but he did state that he'd worked at Clements for a period of time back before 2021, and apparently had been able to work in that employment. Notwithstanding that, the court notes that he'd stated that going forward that he would try to set back some money to pay, but there was no guarantee. So at least that's informing the court that notwithstanding the minimal intent that he has in this matter, that the court is going to get nothing in this particular case, because that's consistent with what's happened previously. So the court will find that he does have the present ability to make an income. He hasn't stated he has any mental or physical disabilities that will keep him from working. He's acknowledged that he does do part-time odd job work and that he's able to do that. As a result, the court will find that he's failed or refused to comply with the orders of the court, and he is in contempt of court. Anything before sentencing, Mr. Sackrider?
Yes, we would ask that the court not impose a jail sentence today, that my client be able to stay in the community and obtain employment to begin paying on his obligation. If the court were to impose a jail sentence, we would ask that it be suspended, or we would ask that the court set a purge amount in the amount of $500. Thank you.
Thank you. Well, in this particular case, the court notes the court could, you previously had one finding of contempt. The court could find you in contempt. You were sentenced to 31 days at that time with, again, a purge amount. The court could sentence you up to 90 days in jail at this time. I'm not going to sentence you to jail to that extent. But I do feel that the jail time is warranted in this particular case. The court will sentence you at this time to 45 days in jail with credit for no time served. The court would order that you report to the sheriff, Calhoun County Sheriff, no later than 4:00 p.m. October 13, 2023. In lieu of that, the court would set your purge amount in the amount of $1,000. If you're able to make that purge amount, then you would not have to spend that time in jail. So with that, court will end this hearing at 11:22 a.m. You're free to go. Have a good start.
Thank you.
Okay. Mr. Campbell, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes.
Court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
Yes.
Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Mr. Campbell is before the court today after we adjourned the hearing from September 27th to allow him court representation. This is a zero support order, so there are no charging support charges, but he is responsible to pay the arrearage at $16.50 a month plus fees for a total of $20 a month. The last payment paid was $9.23 on November 15th, 2022. He's had 5 prior show causes, 4 bench warrants, and 2 findings of contempt. I calculated 2 months worth of $20 because the last order said he was to commence payments in August of $20 each month. That's where I get the $40. However, he was show cause back in March of this year, and that order required him to commence payments of $20 in April. So really, there's been 6 full months at $20 that he has not paid. The arrearage in this case is $5,487.99. And I think that's all I have at this time.
Okay. Mr. Sackrider, do you dispute or contest any statements made by Ms. Petrulio?
No, Your Honor.
Do you have any questions for Ms. Petrulio?
No, Your Honor.
Any testimony, Mr. Sackrider?
Yeah, I'd call Mr. Campbell.
Okay, go ahead.
All right, Mr. Campbell, looks like you are at a job. Is that correct?
Yes.
Where do you work?
Dork Steel.
Say that first part again.
Dork Steel, Flint, Michigan.
How do you spell it?
D-O-R-T, Steel.
D-O-R-T, Steel. Okay.
Yeah.
How long have you been employed there?
Oh, this is my second day.
Second day?
Yes.
All right. How much are you earning there?
I think it's $13.80
per hour.
Yes.
All right. Are you willing to set up income withholding to pay your child support obligation?
Yes.
All right. How many hours per week are you working?
From 7 to 3:30.
Sorry, what was that?
From 7 to 3:30.
How many hours a week is that?
This is my first week, so I don't know how much that will. Cause today is Wednesday, so I'm only gonna have next week a 2-day paycheck.
All right. Did you tell Miss Petrulio that you were employed?
I called her and left a message on the answer machine, and I didn't hear from her. And I called back, and then she told me just get on Zoom. I did leave it on her answer machine that I was at work, and I didn't know if I was gonna be able to make this phone call or not.
All right.
But I made it.
When was the last time you were employed?
Yeah.
When was the last time you were employed?
Last time I employed was at Walmart. Like she said, it's been about 6 months ago. 7 months ago.
All right. Were you aware of your child support obligation?
Yeah, I was aware of it. I just didn't have no funds to do anything with it. So, like I explained to her, that I put in numerous applications and I've done everything that I was supposed to get a job in. It's just where I'm at, just it's up to them. So I got a job now, so I'm willing to, sign the paper so she can take it out of my check.
All right. All right. Thank you. I have no further questions.
Mr. Campbell, in this matter, you worked at Walmart, you said approximately 6 months ago. How long did you work at Walmart?
I was there for about 3.5 months.
Okay.
4 months, something like that.
What happened to that job?
I got sick. I had a stroke.
They wouldn't take you back, is that it?
They wouldn't take me back. The doctor said that it put me on light duty, so I couldn't go back there. So I just got the light duty off of me, so that's why I haven't been able to get a job. So when I got the light duty off of me, now like I said, I'm working right now.
It doesn't look like, based upon the payments and when most recent payment, you didn't pay anything when you were at Walmart. Why didn't you pay anything from that job to satisfy your support obligation?
That's why I was explaining to her. They was taking it out of my check. The FOC was taking the money out of my check every 2 weeks. I got paid, so I don't understand how they didn't get it.
Do you have proof to show that they were taking it out of your check?
Yeah, they got a hold of Walmart. I had to sign the papers. They got a hold of Walmart, and they was taking it out of my check every 2 weeks. They was. Sure was. Like I said, they got a hold of Walmart, and I had to go in there and sign the paper, and then they was taking it out of my check.
Okay, let me ask.
Actually, the very first check I got the money out of there.
Ms. Petrulio, if he was working at Walmart approximately 6 months ago, and he was working for 3.5 to 4 months before that, he would have the payment should have been made before that November 15th, 2022 date. Why is there confusion on the date or the amounts that were received?
I'm not logged into MySys. I'm having troubles in this room logging in.
Okay.
I do show the last payment was income withheld on November 15th of 22, but he said he hadn't worked there in 6 or 7 months. So that was the last payment paid. So my guess is if money was coming in prior to that, and again, I don't have the whole history here, but he wouldn't have paid anything after that if he hasn't worked there in 6 months.
Well, he would have. I mean, we're now in October. He would have been there through April approximately then if it was 6 months ago.
Yeah, that's true. No, nothing paid since then. I recall telling him that last week when we had the hearing and told him he would have to get with him Walmart to discuss if payments were coming out of his check. They did not come to front of the court. Nothing received since November.
Thank you.
Actually, a couple of times when I went to court, I called down there to make sure that they was getting the money, and they verified it. That it was coming out of my check, and my check stub showing me that they were taking the money out of it.
Ms. Petrulio, there were 2 prior contempts. Was he sentenced on those, or what happened?
1 second, let me look. Looks like one was back in 2012, and he was not sentenced on that. That was a contempt finding before the referee. Let's see the other one.
Court will, anything else, Mr. Sackrider?
No, Your Honor.
In this matter, the court's heard the testimony. Is clear that Mr. Campbell was aware of his support obligation, that he had, again, paid on that. Most recent was back in November of 2022. After that date, he would have been working at Walmart. He claims that money was coming out of his paycheck and income withholding, but the court doesn't have anything and did not receive anything. And again, he's just recently returned to work, but he has not made payment for a considerable period of time in this case. And but the court is going to recognize that there may be some confusion or error in this case. What the court will first do is order that Mr. Campbell, that you would acquire your paycheck stubs or some documentation from Walmart to establish what the income withholding was in this case. The court will find that, again, that you have failed or refused to comply. And therefore, technically, you are in contempt of court. What I'm going to do, sir, anything before sentencing, Mr. Sackrider? No. Now, I'll go to you then, Ms. Petrullo. Mr. Sackrider's frozen, then we'll go back to him.
Yeah, thank you. Just for the record, he was sentenced to 14 days on May 26th of 2015.
Thank
that
you.
Was the other contempt finding. And if we can get the name of the employer, I still didn't understand what he said. I tried to look up with what I thought he said.
Okay.
Thank you.
Mr. Campbell, would you spell out again the name of your employer?
Yes, I will. Ask, do she want the name or the shop I'm at, or does she want the name or the temporary company I went to?
The temporary service, if that's who's paying you. And then you can also give me the name of the employer, please.
Okay, the temporary company is Ashley, ASHLOR, staff, STAFFING.
Okay.
And the workshop is Dork Steel, Dork Highway, Flint, Michigan.
Mr. Sackrider, anything else?
No, Your Honor.
Okay. Mr. Campbell, what I'm going to do, court does note that you had a prior 14-day jail sentence. I could sentence you up to 90 days in jail. I'm not going to do that. You're working. We want to continue that. What I am going to do is sentence you to 21 days in jail with 0 days credit. What I'm going to do is I'm going to suspend that jail sentence and stay the enforcement of that until December 6, 2023 at 8:00 a.m. And what we'll do is have you back at that time, and I'll order that you provide those paycheck stubs as it relates to Walmart, so we'll have an opportunity to review that issue, as well as to determine that you have paid in the interim. If I will tell you, if you haven't paid between now and that December 6th date, then you plan on spending that other time in jail. If you are paying currently, and we receive evidence that you did pay from Walmart, then the court will either vacate the sentence or continue to have it suspended in this particular case. You understand that, Mr. Campbell?
Yes.
Okay. So we'll see you back on December 6, 2023 at 8:00 a.m., and then we'll be able to determine how we proceed at that time. Yes, Mr. Trujillo.
The hearing will be at 8:45. It's Miss Brown's case.
Oh, okay.
And then one more thing. Can the amount of collection be increased since he is working now from 20 to something a little bit more to cover this?
We'll address that on the December 6th date, being that he
Okay.
Just start working. So
Yep. So, sir, it'll remain the same. We'll see you on December 6th at 8:45, and we'll proceed at that time. Okay?
all right, thank you.
You have a
Your
good
Honor.
day, and we'll end this matter at 11:40
Civil
a.m.
contempt of court
due your failure to pay child support and related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges, sir?
Yeah.
Court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
Yeah.
And Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay, thank you. Ms. Bladdock, I don't know, did I have you sworn before?
Yes, I did have a previous hearing. Lindsay
Okay.
Milton versus Sean Milton. Mr. Milton is the respondent in this case, currently ordered to pay $364 per month. That is the result of a February 2nd, 2022 support order. The last payment that Mr. Milton made in this case was for $160.97. That was paid on July 27th, 2022 by him, by himself. He paid that on his own. This is the first and only show cause. He's had no bench warrant and one prior contempt finding. This matter was adjourned from referee Del Mont's hearing on August 7th of 2023. Compliance was measured during August and September. He should have paid $364 each month. He paid nothing during that time, leaving him short $728. Current arrearage through the month of September is $5,874.93. It does show that he does have active public assistance and has been denied for both types of Social Security, no VA and no unemployment benefits. There has not been any new medical documentation submitted. He did provide documentation in April, but that documentation does not state that he's unable to work. He was ordered into the LEAP program and failed to participate, and he has no previous jail sentences.
Thank you. Mr. Sackrider, do you contest or dispute any of the statements made by Ms. Platic?
No, Your Honor.
Thank you. Do you have any questions for Ms. Platic?
No.
Any testimony, Mr. Sackrider?
Call Mr. Milton.
Okay, go ahead.
All right, Mr. Milton, can you hear me?
Yes.
Is there anything that you disagreed with that Ms. Platic testified to?
Yes, I wasn't able to get my medical paperwork in on time because the hospitals are still acting under COVID. And when I get a appointment a month or two down the road, last appointment court date, so I had to reschedule that. But I have all my paperwork now, and I have over $5,000 in receipts from things I paid for my son in the past 2 years.
Okay.
Yeah, my medical. I'm not working and haven't been working for a year, and I told him that, and I was assuming my payments each month were going to go down, but.
All right. Were you aware of your child support obligation in the amount of $243 per month?
Yes.
All right. Says here your last payment was on July 27th of 2022 in the amount of $160.97. Is that true?
Yes.
Were you employed then?
What's that?
Were you employed in July of 2022?
I wasn't employed. I did work though. I did like odd jobs here and there.
Okay.
During the time of my medical condition, the reason why I can't.
All right. Have you worked since July of 2022?
Here and there, yes.
Okay. How much would you say you earn per month since that time?
Oh, I have no idea. Just since not, yeah, I would have to sit down and calculate.
All right. How have you been supporting yourself?
I get food stamps. I've worked here and there. I haven't worked lately. I got eviction notice, electricity shut off, and gas shut offs right now.
All right. Where do you live?
Arbor Hill Apartments, 56 or 54 Springview Drive, apartment 306.
All right. How do you pay rent?
I haven't paid rent. That's why I got the eviction notice.
All right. What are your other bills?
Electric, gas, phone.
All right. Is there anything preventing you from finding work?
Yes.
What is that?
My medical conditions.
What is your medical conditions?
I have bipolar, anxiety, depression, ADHD, rupture of my L5 and L11 disc in my back, rheumatoid arthritis, and what we're doing blood work for right now is ever since my treatment of hepatitis C started having these other symptoms, which is what we're going for right now.
All right, Ms. Plattick testified that you didn't bring medical paperwork that said you were unable to work to the last hearing.
Yeah, I did. I brought it, and there was nobody there. They told me to leave and gave me a number to call.
Okay. Have you been paying child support on the side?
Yes. I was,
right.
anyways. Not lately.
How much did you pay in child support to Ms.
Well,
Mullen?
I have receipts for the past 2 years. It's over $5,000.
All right. Why didn't you use friend of the court to pay your child support?
Because every time my son needed something, she would just ask, and we go on and off. Back then, she was gonna write the child support off like she did last time because I paid everything. But it seems that that's not happening this time.
All right. When was the last time you were employed?
Two years ago.
All right. Since that time, let's say per week, how many jobs have you applied to, if any?
In the beginning, 3 or 4 a week before I got my job.
Are you looking for employment currently?
No, not currently.
Why not?
Why not? Because I'm going through this medical issue.
All right.
I applied for disability.
Where are you at in that process?
I already applied. I'm waiting, I guess. I don't know how it works.
All right. What's your plan to pay child support in the future?
I pay what I can. My support at this time should at least be temporarily lowered.
All right. Anything else you want to tell the court?
Oh, that's it.
All right. No further questions.
Mr. Milton, you claim that you tried to drop off some medical documentation, but no one was there. Where did you try to, excuse me, wait till I finish my question. Where did you try to drop off the medical documentation?
When I went to court last week and nobody was there.
And again, I ask you where you went. Court is a nebulous term. Did you?
I had a court date last week. It switched today because we weren't there.
Well, the courthouse is open, sir. You can come here anytime from, 8 in the morning till 5. So what time were you here?
Yes. I was there for my court date at 8 o'clock in the morning. But the caseworker or something wasn't there. They gave me a number to call. I talked to her, told her about my paperwork, and asked her what I'd do with it. She said, you can bring it with you to the meeting or drop it off the court.
Okay.
So I was
and did you drop it off? Did you drop it off since last week?
No, I have it right here.
Well, it doesn't do us much good for you to have it right there when Ms. Plattick has.
Well, that's what I was kind of thinking when she told me that.
And I'm certain that Ms. Plattick told you before last week that you needed to provide medical documentation. Why didn't you provide it before last week?
Because I got it the date. Let me see the date. I picked it up the day before court.
Sir, why did you not participate? Why did you not participate in the LEAP program?
I got a job 2 days before that. I was on a job. My son's birthday, and had no rent.
How long did that job last that you had that kept you from participating in LEAP?
I think 8 days.
Why didn't you go back to the LEAP program then after that 8 days when you were no longer employed?
I had called the LEAP program, or they called me and asked what I was doing, and I told them that I was waiting on my blood work and I was doing disability and stuff, and he said, okay, we'll mark that down.
Well, just because they mark it down when there's an order that you participate, that does not exclude you from participating.
Okay, well, I guess I didn't understand that.
You stated that you work here and there, and what you didn't give a figure to Mr. Sackrider as their average monthly income. Would you please do that now? Just give us an average on your month.
I don't have an average. It could be $300 to $1,500.
Okay, well, that gives us something then. And why haven't you, if that's your average, anywhere from $300 to $1,500, why have you not paid your support obligation if you're making that amount, or at least contribute and pay something towards it?
Because I was paying it straight to her.
Okay. Well,
that's why
you know that the court order requires that you pay that in to the state of Michigan, not to the payee.
Right. When I talked to my caseworker the last time, she said if I had receipts going to my son, then it would be considered child support.
Anything else you'd like me to be aware of, sir?
No, that's it.
Ms. Milton, is there anything you would like to say in this matter?
No.
There's the claim by Mr. Milton that he had given you a substantial amount of money for, or provided various items. As he stated, he had $5,000 in receipts over the past couple of years. Is that an accurate picture of what he's contributed to the child?
No. So Sean does spend a lot of money on his son. He doesn't give me money directly. He pays his cell phone bill just about every month. I think it's $30, $40. I think he's handed me the $30 or $40 once to pay it for him. He bought him a backpack and a pair of shoes for school. He helped pay his taekwondo testing fee a month or two ago. That was $60. What he takes him on, vacations and does fun stuff with him. I believe that's the receipts he's talking about. He doesn't give me money directly. He would like to just buy him stuff on his own, which that's nice, but that's not helpful all the time.
Thank you. Well, the court will make the following finding in this particular case, that Mr. Milton had testified that he was aware of his support obligation, that his last payment was in July of 2022. So now it's well over a year, that he works odd jobs now and then. He said making on average $300 to $1,500 per month, that he, again, didn't participate in the court-ordered LEAP program because he had a job that lasted 8 days, but after that time, he didn't do anything to get back into the LEAP program, that he has previously filed apparently for disability, et cetera, and been denied that. He has stated he has refiled, but again, that was denied previously. He has stated that he has paid various expenses for his son, but as Ms. Milton stated, is not given and paid anything direct to her. It doesn't help her to defer the cost of the child because he's paying for vacations or things of that particular matter, where, again, she is a custodial parent. She has the responsibility to raise and to pay the expenses for the child. She's not able to do that if the the payer is making his own choices as to what he is paid. That's not how support works. Court will find that Mr. Milton does have the present ability to make payments, that he does have income which he could utilize to pay support, that he's failed or refused to do so. He is therefore in contempt of court. Anything before sentencing, Mr. Sackrett?
Your Honor, we would ask that the court not impose a jail sentence if they are so inclined, that jail sentence be suspended so that my client can find gainful employment. If the court does impose a jail sentence, we would ask that a purge amount be set in the amount of $250. Thank you, Your Honor.
Thank you. Well, what the court is going to do is, Mr. Milton, you had a prior contempt finding. The court could sentence you up to 90 days in jail. I'm not going to sentence you to that amount of time, as it would be the first jail sentence you have. But I do believe that based upon what the court has heard, that you have to be impressed upon you that, in fact, you have to comply with the orders of the court, that you can't, in fact, pick and choose when you're going to do so. What I'm going to do is I'm going to sentence you to 21 days in jail with credit for no time served. The court will order that you report to the Sheriff's Department no later than 4:00 p.m. on October 13, 2023. In lieu of that, the court would allow you to purge yourself of contempt in this matter by paying the sum of $500. If you pay the purge amount, then you would not have to go to jail. Otherwise, you'll have to report to the Sheriff's Department on the October 13, 2023 date. With that, the court will end this matter at 12:01 p.m. You're free to go.
It's
have
Tracy
a good day.
Bailey versus Rebecca Bailey. In this matter, Rebecca Bailey is ordered to pay $320.16. That is a result of an order confirming registration out of Indiana from May 31st of 2019. In this matter, compliance was measured over 12 months at that amount. During that time, she made one payment of $20. That payment was made on September 26th of 2023 on her own. It left her short $3,821.92 for those 12 months of compliance. There is still a $300 bond that Ms. Bailey posted on August 7th of 2023 that friend of the court's requesting be forfeited and applied. Current arrearage in this matter is $13,125.21 through September. There is report that she receives public assistance and she does have pending Social Security claims, no VA or unemployment benefits. There are no previous jail sentences in this matter. And at the last hearing, she was ordered to submit new medical documentation. She did submit a new letter dated September 6th of 2023 that came from Greater Michigan Spine and Neurological Institute. However, it's insufficient medical documentation. It only submits the above referenced patient is under my care for a neurological issue. Surgery services are being offered to that patient. This documentation doesn't state her diagnosis, prognosis, or her abilities to work at this time.
Okay. Mr. Sackrett, do you contest or dispute any of the statements made by Ms. Flattick?
No, Your Honor.
Have any questions for Ms. Flattick?
Does she qualify for the LEAP program?
I believe she does. Hop over. Yes, I believe she does.
All right, thank you. No further questions.
Thank you. Any proofs, Mr. Sackrett?
I'd call Miss Bailey.
Okay, go ahead.
All right, Miss Bailey, can you hear me?
Yes.
You heard the testimony of Miss Flattick. Was there anything that you disagreed with?
I know that she didn't read the rest of the letter where it says if you guys have any questions to give them a call.
All right, so yeah, she testified that you did submit medical documentation, but that it was insufficient. What is your medical condition?
I have 3 fractured vertebrae. I have 4 screws in my L5 and S1. I have to have a hip replacement in my right hip due to a tear in my labrum. I have to have pins put in my SI joints because they are bone on bone and rubbing together, which causes me a lot of extra pain that I really can't handle. I have gone through multiple medical issues. try to deal with this, but unfortunately, nothing has worked. And right now, we are waiting on Allstate to make payment to Dr. Spencer's office so I can go ahead and get my surgery for my SI joints done within this year.
All right, are these the injuries the result of a car accident?
Yes.
When was the car accident?
The car accident was in May of 2019.
All right, has the injuries from that accident prevented you from working?
Yes.
Have you received any compensation for the vehicle accident?
Not at the moment.
All right, have you applied for any wage loss benefits or any other type of benefits?
Yes, we're actually in the middle of a lawsuit.
All right, do you have an attorney for that lawsuit?
I do.
Okay. All right. She testified that your child support obligation is out of Indiana from 2019. Were you aware of a child support obligation?
I was aware.
When did you become aware that it was transferred to Calhoun County, Michigan?
About 6, 7 months after.
All right. How did you receive notice?
The mail.
All right. Says here your last payment was $20 on September 26th of 2023. Is that correct?
Yes.
Where did you find the money to make that payment?
I have a small job that I work once a week. I just recently got it, and I get paid $80. So I put the $20 I had left after making sure that I was okay with my medications for the week. I went down and I put it on child support. The judge asked me to pay. I'm doing the best I can with what I can.
Where do you work?
For Richardson Construction.
What do you do there?
Basically, I just clean up the trailers. Sweep them, make sure that all the tools are in the right place.
All right, you said you earned $80. What time frame is that earned?
Usually it's like 9 to 12.
You earn $80 per day or per week?
Per week.
All right, so you earn $80 per week. How long have you been employed there?
Since last week. I've been looking for a job that would be lenient with my medical conditions, and this was the only one that I could find.
Okay. Prior to obtaining the job last week, how are you supporting yourself financially?
My boyfriend and my mom and my brother were all helping me.
All right. Have you applied for Social Security disability?
Yes, I have.
What's the status of that?
Right now, they keep denying me due to insufficient medical reasoning. Now my attorney is going to be helping me go back through that again. So hopefully this time I can actually get it without having to deal with all the rejection notices.
All right. Ms. Platic testified that you would be eligible for a LEAP program or other type of employment help. Would you be willing to participate in that?
I'm not sure what the LEAP program is.
All right. Would you be willing to have friend of the court help you find employment or help you find an agency that would help you find employment?
Yeah.
All right. Anything else you would like to tell the court?
I'm doing the best I can right now. With my medical conditions and surgeries coming up, I'm trying. I want to see my kids. I don't even know where they're at. I have no way of contacting them. I can't see them. He denies me even a simple phone call to my children. The address that he's given the courts is a fake address. And when Judge Kirkham had awarded me custody in Calhoun County when I started a divorce from him, I went down there twice to get my kids. Both times I had the cops called on me, saying that I was attempting to kidnap my own freaking kid. When that wasn't true, I was just trying to go enforce the order that was given to me.
All right. All right. Thank you. I have no further questions, Your Honor.
Ms. Bailey, what I'm going to do in this matter, first, a couple things. First, at this point, I'm going to forfeit the bond previously posted in this matter. I'm going to adjourn this matter to December 20, 2022 at 8 o'clock a.m. That'll allow you time to get the appropriate documentation into the front of the court. You're going to have to get something from your doctor saying either if you can't work, that you can't work. You need a prognosis and a diagnosis, as well as a statement of whether you can work. So just saying you're under your care, the doctor's care, is insufficient. So that you know that, you're going to have to do that. The court is going to order that you participate in the LEAP program in the interim. And again, that you provide the front of the court with the information as to your attorney that is handling your disability claim, so that they can be contacted if we need to. And the court would order that you continue to pay, or at least pay something in the interim, out of the income that you have with Richardson Construction. If, again, if you don't provide any of that information or documentation, or you don't participate in the LEAP program between now and then, I will tell you, I am saying at that point, but I would tell you, be prepared to go to jail. You understand?
Yes, sir.
So you've got this last opportunity. I'm not going to come in on December 20th and have you say, well, geez, I didn't get this now, or I wasn't able to get it. That's why I'm adjourning the matter over 2 months, so that you can get all that in, and that we'll have all the information we need in this particular case. So that will be the order. We'll see you back on December 20 at 8 o'clock a.m. and we'll deal with and take care of everything at that point. The court will preserve all of the proofs taken at this time, so we don't have to go through it again.
Yes, sir.
Okay. Thank you. The court will end this matter at 12:13 p.m. You're free to go. Have a good day.
Thank you. You too.
Did you have something else to say, Katie?
I was just going to ask that it be 8:45 and not 8 o'clock.
Okay, 8:45. That's right.
Here.
Oh man, that's always a pain when we have an interpreter.
Well, they requested it.
Yeah, I know. They just take forever.
It takes a little bit long. Let's see.
Good afternoon.
Okay. This matter is before the court for a revocation of paternity action. And as a result, this was filed by, no, let me see. Thought I had that down in my notes and I don't. Hold on. Filed by the plaintiff in this particular matter. Ms. Rodriguez, are you ready to proceed?
Yes, I am.
Okay. And Mr. Rodriguez, are you ready to proceed?
Yes.
And Mr. Miller, are you ready to proceed?
You need to unmute, sir.
Ma'am, what would you like to tell me?
What would I like to tell you?
Yes.
That I'm revoking paternity for my son, Xavier, and that Francisco in the state of Michigan is seen as the perceived father, but Gregory Miller is actually the biological father.
Okay. And in this particular matter, I don't have a date of birth for Xavier. What is the date of birth?
2023.
Thank you. So that would put date of conception to be sometime around September of 2022. Is that correct?
Yes.
And at the time that conception in September of 2022, were you engaged in any sexual relations with the defendant?
No.
Were you at that time engaged in sexual relations with Mr. Miller?
Yes.
And anyone else besides Mr. Miller?
No.
Has the defendant, Mr. Rodriguez, had any parent-child relationship with Xavier?
Could you repeat the question?
Yeah. Did the defendant, Mr. Rodriguez, since the date the child was born, has he had any parent-child relationship with Xavier?
No, he's been around him though.
Well, but has he had any parent-child relationship?
Can you define that?
Well, it would be the relationship that you would have with a child, where typically, if you have other children, you'll know that obviously you have a loving relationship, a supportive relationship, a nurturing relationship, all sorts of things that a parent and child would do. And that is what I'm referencing. Ms. Rodriguez, has he had that type of relationship with Xavier?
No.
Has Mr. Rodriguez assumed and taken any financial responsibility for your child?
No.
Kind of in the same line, has Mr. Miller assumed a parent-child relationship with Xavier?
Yes.
And how would you describe their relationship?
I would say like a fatherly son relationship. They've seen each other. He's been around. He gives him everything he needs. So.
And does Xavier look to and look at Mr. Miller as his father?
He's quite young right now, but he does recognize him.
Has you said that Mr. Miller gives him everything he needs. So has he taken financial responsibility for Xavier?
Yes.
Thank you. Is there anything else you would like to add, ma'am?
No.
Okay, thank you. Mr. Rodriguez, do you have any questions for plaintiff?
No, Your Honor.
Thank you. Mr. Miller, do you have any questions of the plaintiff?
No, no questions.
Okay, thank you. Any additional witnesses, Ms. Rodriguez?
No.
Okay. Sir, you've heard the testimony of your wife in this particular matter, and do you believe that testimony is accurate?
Yes, Your Honor.
At the time of conception of the child in September of 2022, were you engaged in any sexual relations with the plaintiff?
No, Your Honor.
And have you, in fact, carried on any parent-child relationship with Xavier since Xavier was born?
No, Your Honor.
Thank you. Is there anything else you'd like to add, sir?
No.
Ms. Rodriguez, do you have any questions for defendant?
No,
Sorry, the alert is going off right now.
Ma'am, I asked you and I didn't hear because that emergency alarm went off. Is there anything you'd like to ask of the defendant? Ms. Rodriguez?
Yes.
I asked you if you had any questions for defendant.
Oh, no. No questions.
Okay, thank you. Mr. Miller, do you have any questions of the defendant?
No.
Okay, thank you. You've heard the testimony of the plaintiff in this matter, in which she stated that on or about the time of conception, September of 2022, that you and she were engaged in sexual relations. Is that accurate?
Yes.
And since Xavier was born in May of 2023, have you carried on a parent-child relationship with him?
Yes.
You understand that by, again, acknowledging that you are, in fact, the biological parent of Xavier, that takes and has certain financial responsibility.
Yes.
And are you willing to accept that, sir?
Yes.
Any doubt in your mind that Xavier is, in fact, your biological son?
No.
Anything else that you would like to add, sir?
No.
Thank you. Ms. Rodriguez, looks like that concludes the proofs in this matter. Do you have any closing statement to make at this time or not?
No.
Okay. Well, the court will make the following ruling in this particular matter that, in fact, Xavier, who was, in fact, born in May of 2023, giving a date of conception of September 2022, that, in fact, at the time of conception, that the plaintiff was engaged in sexual relations with Gregory Miller, that she was not engaged in any sexual relations with the defendant at that time, that she has testified that the defendant and the child do not have any parent-child relationship, that he has not accepted or taken on any financial responsibility for the child, Xavier. In contrast, she testified that the father-son relationship is with the third party, Mr. Gregory Miller, that Xavier looks to him as his father and recognizes him as such based upon a child of this young of age, that Mr. Miller has taken financial responsibility for the child. The court will note that Mr. Miller has, in fact, stated that he has accepted financial responsibility for the child and, in fact, acknowledges all the facts as set forth in the plaintiff's testimony. As a result, the court will determine that, pursuant to MCL 722.1441, that, in fact, Xavier is a child born out of wedlock, not issue of this marriage, and that Gregory Miller is the biological father, and that, in fact, he would then have responsibility for that particular child. In this particular case, I'll ask you, we did not have, I know you submitted a DNA test report, which was a home health DNA test from Genovat. You understand that?
Yes.
Okay, you understand that is not admissible in court, as it is not, does not follow the criteria necessary to admit a test like that, because it's not, first of all, it's not signed by anyone. It, again, does not confirm that it is a valid test as required by statute, and that is to, in this matter. So I guess I'll ask you at this point, if you, is there a reason you didn't have a valid?
Because the last court hearing we had, you said I can just get one from the store and do it at home instead of going through front of the court because it would take longer.
Well, okay. The problem is you can do that, but the problem is it's not admissible. So I can take some testimony today. We'll take the testimony that we can and determine whether it's sufficient. If it's not, then the court would make you then proceed with a valid test at that particular time. So,
okay.
Ms. Brown, do you wish to make an opening statement or simply proceed to proofs in this matter?
I say, I'm going to say what I said last time is pretty much, well, I haven't been with Matthew Brown since 4th of July of 2020. And
okay, hold on.
Hold
on. I was asking if you were going to make an opening statement. If you're going into testimony, I'm going to have you sworn in first. Thank you. Go ahead and tell me what you'd like me to be aware of, Ms. Brown.
I left Matthew Brown on 4th of July of 2020. I was with John Taylor from the beginning of November of 2021 till the end of June of 2023. He's the only person I was with for almost 2 years. He is Xander's dad.
Okay. Just because I'm going to need that, what is the date of birth of the child?
23.
And since Xander was born, has Mr. Brown had any relationship with Xander?
No.
Has he accepted any financial responsibility for the child?
No.
Has Mr. Taylor engaged in a parent-child relationship with Xander after his birth?
Yes.
And what kind of things has he done?
Well, we separated in June, but he takes some he's been taking them on and off. We don't have no scheduled days. He helps provide for him. When we were together, he was watching them while I worked.
Okay. And did he accept and provide financial support for Xander when you were together or after that?
Yes.
Has Mr. Taylor ever contested or disputed custody of Xander?
No.
Yeah, I think I said custody. I meant paternity in this matter.
No.
So the time of conception of the child was approximately October of 2022. Is that correct?
It would have been like, I think it was around, he was supposed to be due in April. He was a preemie. So I'm pretty sure it would have been around July, August of last year.
And he was due when, in April?
Yeah, he was due towards the end of April. He was born at 37 weeks.
Okay. So at the time of conception, you were not engaged in any sexual relations with Mr. Brown, correct?
No.
And at that time, you were engaged in sexual relations with Mr. Taylor?
Yes.
Okay, thank you. Is there anything else you'd like to add, ma'am?
No.
You'd heard the testimony of your wife in this matter, testifying concerning your relationship. Is in fact her testimony accurate and correct?
As to my knowledge, yes, it is.
Okay, so you did in fact leave and separated on or about July 4, 2020?
Yes, it was exactly on July 4th.
And after that date, and at the time of conception, which she said would be July, approximately July of 2022, you did not engage in sexual relations with Miss Brown. Is that correct?
That is absolutely correct.
Mr. Brown, or Mr. Taylor, you've heard the testimony of Miss Brown in this case. Does her testimony appear to be fair and accurate?
Yes, sir, it does.
At the time of conception of the child on or about July of 2022, were you engaged in sexual relations with Miss Brown?
Yes, sir, I was.
And since the child was born in March of 2023, have you engaged in a parent-child relationship with Xander?
Yes, sir, I have.
I'll conclude the proofs in this matter. The court will make the following determination that court is called upon to determine that the child is a child born that is not issue of this particular relationship between the or the marriage between the no, it's a DS, so it's not a marriage between the Miss Brown and Mr. Brown. In this particular case, the court will note that the testimony of Miss Brown, which is determined to be accurate by both of the other parties in this matter, is that on or about July 4th, 2020, that the parties separated, that she had not engaged in any sexual relations with Mr. Brown after that date, that the date of conception of the child would have been approximately July of 2022, that at that time she was engaged in sexual relations with Mr. Taylor, that that following the date of birth of the child, that Mr. Taylor has taken responsibility for the child, both caring for the child personally and also taking financial responsibility, that he has not ever contested paternity in this case, and in fact acknowledges that he is in fact the biological father in this matter, born in March of 2023. He has acknowledged, Mr. Taylor has testified that Ms. Brown's testimony was fair and accurate, that he is engaged in a parent-child relationship with Xander after the child's birth. He continues to care for Xander, and again, will accept financial responsibility for the child. That being said, the court will, pursuant to Michigan Court Rule 722.1441, determine that, in fact, Xander is a child born out of wedlock, not issue of this marriage, and in fact, that the biological father is John Robert Taylor. And that will conclude the matter. The court will prepare the appropriate order and fill that out. And anything else, Ms. Brown?
No.
Mr. Brown?
No.
Mr. Taylor?
No, sir.
Okay. Thank you all. The court will end this hearing at 2:45 p.m. You're free to go. Have a good day.